All right, welcome back. This is the capsule on the reference regarding same-sex marriage. So first, what do we look at for this week? Essentially, of course, this case is going to have Section 15 at least underpinning because our focus for this course has obviously been on Section 15. However, we see it from somewhat of a different perspective there. Section 15 is not applied, or discussed in a kind of detailed and textured way in the same way as we usually see it. However, what we do see are two interesting things, broadly speaking, that we've considered in previous weeks, So first, we're going to consider the impact of Section 15 on other sections of the Charter, as we've seen before, and here specifically on the rest of the Constitution, because 15 is part of both the Charter and the Constitution, the Charter being part of the Constitution, of course. We saw that Section 15 applies to other legislative enactments, because the Charter applies to public action generally, which includes laws, and Section 15 specifically applies to a narrower scope of public action, namely distinctions made under the law, pursuant to the law, ability to be equal under the law, These phrasing kind of broaden the sense of a law to say its application, but still there has to be a law, So 15 and the Charter generally do apply to laws. However, 15 also is used here as an interpretive aid to understand other sections of the Constitution. And we'll see that's very helpful and interesting, So 15 is not used here as a limit, as we usually see it, as a way to prevent certain state action, but it's not really used as an empowering tool, as we see under 15.2 for ameliorative programs either. Instead, 15 is used to interpret other sections of the Constitution. Namely because the enactment of the Charter generally, and the enactment of 15 specifically, with its very important yet broader values of equality and non-discrimination, is obviously going to tell us things about the intent of the people who wrote the Constitution, and who amended it in 1982 with the addition of the Charter. So it's going to be helpful as an interpretive tool in that way, and 15 specifically because first 15, sets out these important values of equality, which are more aspirational and kind of broader, harder to define than the things we usually see in the constitutions, That don't just tell us, that much about the intent of the framers, because they're the typical constitutional rights we think about. Right to life, right to liberty, not to be tortured, not to be treated cruelly or unusually, right to freedom of religion. These are all things that we usually find in constitutions. The right to equality and to be free from discrimination is different. It's kind of a second wave as we usually consider them in international instruments, because it's not a strictly necessary, thing like life is. Instead, it's something that adds to our lives and that helps us further pursue certain values that we think are important to the human experience. And in that way, generally, we see the recognition of rights like equality and non-discrimination later on in the constitutional evolution of a developed country, after certain rights have been recognized, and generally also after a certain level of wealth has been accrued in a country. And on top of that, 15 has a recognition of substantive equality. So as we said, 15.1 is always interpreted as part of this paradigm of substantive equality, So we don't want people to just be treated the same. It's not our conception of equality. At least it's not why we would have needed to pass Section 15 as part of the Constitution. Instead, we want substantive equality, We want a more nuanced perspective where We consider the specific circumstances of various groups of people. And also, right, try to help further that conception and make people more equal. That's what 15.2 is there for. 15.2, right, is under the same paradigm of substantive equality, as we've said multiple times, but 15.2 is also a clear recognition of that, right? So in 15.2, we allow ameliorative programs, of course, that, right, help further equality, right, to draw distinctions, to be discriminatory in some sense against some people, to help a group that needs help, and that's allowed under the Constitution. In 15.2, we see that recognized explicitly. So 15.1 just says you have a right to be equal. It doesn't say you have a right to be equal substantively. However, 15.2 says something that's intrinsically, right, grounded in this conception of substantive equality, and that is this idea that certain distinctions are okay, that, right, reverse discrimination, as we saw, is conceptualized in the United States as unconstitutional in some circumstances, is generally okay in Canada because we want to proactively help certain groups that have been traditionally marginalized. So 15 is helpful in that sense as an interpretive aid because it tells us about these important values of substantive equality and non-discrimination. And therefore, the court here is asked to interpret the power of the federal government to legislate. So we have two sections, right, in the Constitution, not the Charter, so the original Constitution, 1867, that say what the federal government does and what the provincial government does, right? We live in a constitutional democracy where we have enumerated powers, right? Federal government's going to do certain things, and the provincial governments are going to do certain things. It's not one has, right, things that are set out and another has the rest. There's enumerated powers for both under these sections. And therefore, of course, if the federal government passes a law that is not within its list of things it can pass laws on, right, then that law is going to be what we call ultra-virus, in other words, invalid, because the federal government has the power to pass laws, but not just any law, right? A law that respects the Constitution, which includes the Charter, but which also includes, right, its legislative powers is enumerated under these various sections. And here, the court interprets the federal government's power to pass laws, and in doing that, resorts to Section 15 of the Charter. Interestingly, as noted by the Supreme Court, Section 15, of course, didn't exist when the Constitution was passed in 1867, right? It came about over 100 years later when Trudeau père traveled to Europe and brought it back, right? However, of course, passing the Charter is a recognition of certain values, and these apply even to existing legislative enactments and even as interpretive aids. So we interpret, right, these powers, and that tells us about the underlying important values that we find within Section 15. So what do we have in this case, right? We have a reference. It's interesting, right? We haven't had that before. Usually there's two people or entities, and then there's a V in the middle, right? People fighting. You have one person asking for something. Generally, you have another person that says no, right? And oftentimes, in the case of Section 15, that someone is going to be a someone, and that other someone is going to be the government. And someone's going to say, the government has wronged me by passing a law that is not valid because it's not constitutional, by passing a law that does not respect my constitutional rights. And generally, the government, except under certain exceptions, as we saw under 15.2, Section 1, and so forth, right? Generally, the government can't pass laws that infringe upon constitutional rights. Here, though, there's no parties. It just is reference regarding same-sex marriage. It's kind of weird, right? We don't have people fighting. Why is that? Very unusual. Well, because the Supreme Court doesn't just have power to hear litigants. And so we move away from this standing issue. You'll recall I said multiple times, right? You have to have a dispute to go to court, and it has to be live. So you can't go to court and say, my neighbor's rights have been infringed, or I think my rights are going to be infringed someday. It doesn't work that way. can't go to court without a reason to be there, right? So you can't go to court and say, this law is not valid. You can say that, but the law has to affect you personally, otherwise you don't have standing. So you might be a very well-meaning lawyer, right, who understands laws and realizes that this wicked federal law is not constitutional, but that doesn't allow you to go to court and say this. You might know it, Supreme Court might know it, Supreme Court can't just strike it down, it doesn't work that way. You have to have dispute, and it has to be live, meaning that if that injury disappears, so does your standings. If the government gets rid of the law that's not constitutional, well then your right to be in court generally goes away as well because that dispute is no longer live. That remains true. However, there is an exception specifically for the Supreme Court only in Supreme Court Act, where the Supreme Court has the power to also consider questions from the federal government. So the federal government can ask questions to the Supreme Court. So the federal government's not happy with its 20,000 lawyers in the Justice Department, right? The government can call up the Supreme Court and ask a question, generally, a legal question. And we see quite a number of very relevant references, as they're called, in the constitutional history of Canada, which really under the Charter has been for just under 40 years. And we still see a number of interesting references even within that time period. So we see, for instance, a reference regarding secession in Quebec, where the government said, what happens if, right, Quebec tries to secede from the country? And the Supreme Court answered that question. It's helpful because you don't wait for litigants there. So, of course, the government sometimes is going to want to, pass a law that's constitutional, especially on an issue such as this one, right? The government says, yeah, we're starting to get into trouble with same-sex marriage, right? So in various provinces, right, some courts have said that the exclusion of same-sex marriage is not constitutional. And it makes sense under what we know about Section 15, right? Section 15 says you can't draw a distinction as discriminatory, and pursuant to the Vrion case, which we read, sexual orientation is a ground. It's an analogous ground. It's not an enumerated one, but it's one of the things you can draw a discriminatory distinction on. So that's the test, right? So, of course, if you tell people you can get married unless you're gay, well, first it's a distinction. Unless you're gay, it's this distinction, right? And second, it's discriminatory because it plays into historical disadvantage. And we know as well from the Vrion case that that discrimination is not a, and I want to be careful here, this case predates the Vrion case, right? But the principles do apply regardless. And Section 15 says, right, the Vrion case says sexual orientation is an analogous ground, right? And it also says that people of different sexual orientations have been traditionally disadvantaged, which certainly makes sense, right, based on common sense. That's why the court takes judicial notice of that. And so the government starts getting into trouble, right? Federal government thinks, right, ostensibly left-leaning government at that time, says, we'll just pass a law that makes same-sex marriage legal across Canada. Because, there's been all these rulings in the provinces, and it does seem like public opinion has turned. One of the reasons for that, quite interestingly, is that these things didn't go to the Supreme Court. Believe it or not, right, regardless of all these cases we read, we don't just have the Supreme Court in Canada. And in fact, we don't just have the Supreme Court in Canada making important decisions. And that happened in other cases. For instance, we have a case called Carter that says you can't criminalize assisted suicide, basically. So you can't criminalize helping someone commit suicide when they want to and they suffer. And then the government passed a law, because the government respects, right, its constitutional imperatives. But the law says you have to have a terminal illness. Your death has to be reasonably foreseeable. And people said, yeah, that's not really what the Supreme Court said. And more importantly, based on what the Supreme Court said, it doesn't seem to respect the reasons the Supreme Court said that. Namely, the right to life, liberty, and security of the person. Interestingly, 15 is also invoked in Carter, but the court exercises its discretion to rule under 7 not 15. And then what happened? You have a ruling from a Quebec court that says this requirement of your death being reasonably foreseeable is not constitutional. And then the government, right, despite what we saw multiple times, doesn't fight it. It doesn't go to the Court of Appeal and then the Supreme Court, right, because it assumes that the people on the Supreme Court are smarter and they're the ones that are going to make that decision. And also because, right, the government oftentimes really tries to do the right thing, right? So there's a law and it's not constitutional, and there's some public consensus as to the fact that the modification is appropriate. There is really not much of a reason for the government to just try to win in court by saving the law. Oftentimes the government will, but sometimes there just won't be a reason for it, right? So what happened there, the Trudeau government just accepted the Quebec court's ruling, said, okay, we'll fix the law. We'll remove that impending death requirement. We won't go up to court appeal in the Supreme Court. That's exactly what happened there. You had a bunch of courts, right, and for reasons not relevant here, or relevant here but not relevant for the purposes of our course, right, these courts in various provinces made individual decisions regarding the legality of the exclusion of same-sex marriage, and found that it violated Section 15 for the reasons I mentioned. And then, right, federal government says, okay. And interestingly, right, there seemed to be a change in public opinion because these cases didn't go up to the Supreme Court. The Supreme Court says that in declining to answer reference question number 4, says, right, there was a right of appeal that was not exercised. What does that mean, right? When the Quebec Superior Court, whatever Superior Court it was, says this exclusion of same-sex marriage is not constitutional, the government, if it disagreed, right, in that case the provincial government, could have fought it over all the way up to the Supreme Court. As I said, chose not to do that. That's the right of appeal that was not exercised. And therefore, the Supreme Court declines to answer reference question number 4, right, which has to do with the provincial exclusions on same-sex marriage. But all that indicates there was a change in public opinion, right? Ostensibly, the reasons the provincial governments did not fight it over is precisely because it wasn't worth it, right? It did seem unfair to exclude same-sex marriage. Really, it wouldn't kill you at the polls if you changed it. So provincial government said, there's really no purpose in doing that, so we'll just fix our laws. And here what happens, the federal government takes a cue from that and says, well, we got the power to define marriage based on the Constitution. We got a power to say what marriage is. And you have this division of duties between under 92, right, which essentially says federal government has power over marriage, provincial governments have the power over, quote, the solemnization of marriage. What does that mean? Well, federal government says what marriage is, so it's going to define marriage. And it's also going to define, right, the lack of marriage, and that is divorce. That's why the Divorce Act is a federal law. However, the solemnization of marriage is a provincial competence, and therefore, right, everything else is going to be provincial. The certificate you get, who can preside over your marriage, what paperwork that person has to fill out with the government, so on and so forth. So federal government then has the ability to say same-sex couples have access to marriage because it has the power to define marriage pursuant to the Constitution, that separation of duty under the Constitution Act 1867. Federal government is going to do just that. It's going to pass a very sophisticated law that says, 1, marriage is the union between two persons to the exclusion of all others. Quite notably, not two persons of opposite sexes, just two persons to the exclusion of all others, which is the other marriage part, right, that we've always had for about 400 years and more, right? The exclusion of all others. That's why we define marriage. It's exclusive, and, right, on top of that, it's been construed as opposite sex beforehand. And second, it's going to pass a provision which we'll see is not going to withstand scrutiny, to the effect that essentially if you're a priest that doesn't like homosexuals, you don't have to preside over their marriage. And the federal government, before doing that, so not to have to wait a couple of years until someone contests it, because the federal government ostensibly first here clearly wants to pass a law. So first, doesn't want to wait a couple years to find out that it's been struck down, and second, just wants to design it right in the first place, and so asks a question of the Supreme Court. And that question is my law with these two nice provisions, right, constitutional? Is it compliant? And also asks a question regarding the provincial definition of marriage, right, which the Supreme Court is going to decline to answer for the questions, for the reasons that we'll see. The Supreme Court says basically, first, yes, that definition is constitutional. And in doing that, interprets with Section 15, says, right, you're broadening the definition of marriage to persons of the same sex. That is clearly consistent with Section 15 of the Canadian Charter, because you're making things more equal. You're removing an exclusion, and in fact, as we said, that inclusion has been found to be invalid in a lot of provinces, right? You're removing an exclusion based on sexual orientation. That furthers 15, doesn't impede 15, and as the Supreme Court says, right, there's no distinction there. If there is one, it's one that you're removing. It's not one that you're drawing, so you can't prevent that provision under the 15 test, because the 15 tests require a discriminatory distinction under the law. And the Supreme Court's also going to say that yes, that the proposed provision, the proposed provision that allows religious objections is not valid. But not because religious objections are not valid, in fact they almost always are, simply because it's outside of the scope of what the federal government can do. Namely for the reasons I said, because federal government doesn't have power, contrary to the provinces, over the solemnization of marriage. Well, to say, right, someone can formulate a religious objection to a marriage, well, that is, right, a specific detail as to the circumstances in which you can solemnize marriage, and therefore it's about solemnization marriage. It's a provincial, it's within provincial jurisdiction. And interestingly, you see that recognition of the living tree doctrine. So what's the living tree doctrine? Well, there's this case that we call it the Persons case, right, which had to do with basically women going to the Senate, and some very smart person went to court and said, well, women aren't persons because they weren't in 1867 when the Constitution was passed. And that was before we brought our Supreme Court back to Canada. So the final Court of Appeal, that's why you see a bunch of lords there, was the House of Lords in Great Britain, right, which is pretty cool. There are people who actually wear wigs and have to wear wigs by law. And then these lords said, yeah, it doesn't make a lot of sense, right? World changes, and women are persons under the law now, even if they weren't in 1867. This person's case, 1929, I think, right? But significantly, the House of Lords is going to establish that very important doctrine of the living tree. And that's significant because that means our constitutional interpretation is bounded in Canada in a different way than in the United States. So you'll recall substantive equality, I said in an earlier lecture, right? Even though it might be considered a left-leaning concept, you can't really be a right-leaning judge in the Supreme Court and refuse to apply it because it's in the provision. It's clear legislative intent. You don't have to interpret the provision. In that case, right, your own policy views might, to some extent, have an impact, right? It doesn't work that way because 15.1 clearly incorporates substantive equality, specifically with 15.2 and the intent of the people who framed Section 15. Similarly here, Living Tree Doctrine is going to say we have a progressive, and that's the actual word used by the Supreme Court in that reference, a progressive interpretation of constitutional rights and of the Constitution itself. It's the Living Tree Doctrine. The Constitution is capable of expanding in meaning within its natural limits. So not crazy expansion, but some expansion. And so we don't really have theories like originalism in the United States where, right, we think the intent of the framers and the scope of what they were intending to do is very important, because since 1929, constitutional law in Canada has been settled on this. So you can't really disagree on that, even if it's your policy preference. And so the Supreme Court is going to interpret, is going to use both Section 15 and the Living Tree Doctrine to interpret the objections to the competence of the federal government to pass this law. And interestingly, right, the court's going to say that the expansion to same-sex couples, right, doesn't draw a distinction, of course, also doesn't take any rights away from heterosexual couples, right? Getting access to more people doesn't take anything away from people who currently have access. It's one of the arguments rejected by the Supreme Court. And the court adds, right, that the purpose, far from violating the Charter, quote, flows from it. And that Charter rights and values enrich our society as a whole, and the furtherance of these rights cannot undermine the very principles the Charter was meant to foster. Again, very strong language there, and quite interestingly, the Supreme Court is going to be unanimous. So 2004, quite a while ago, right? So halfway through this constitutional evolution between 82 and today, and again a unanimous Supreme Court. This has become relatively usual in our 15 cases, but in the real world, it's very unusual, and that sends a message for the Supreme Court, right? The 9 people who seemingly can never seem to agree on anything because they're too smart, right? That they all agree on an important issue like substantive equality, and like here, the constitutionality of an amendment regarding same-sex marriage. And of course, the argument's not whether, right, they would have favored same-sex marriage, then that might have yielded a different response. The only question was whether the Constitution prevented same-sex marriage. So regardless of your policy views there, that was a very difficult argument to make. And as we'll see, the court, right, that's because it's generalized, right? So you might say, in some circumstances, you should have limits to same-sex marriage, like, for instance, right, forcing or not forcing someone to solemnize it. But here, it's a reference. It's the entire law. The government says, can we pass this law? If the Supreme Court says no, there's just no law. So it's the grossest overgeneralization in a factual conclusion that could ever happen. So we'll go through the case now in a bit more detail, right? These are all the relevant points. It's from the headnote. We'll get a few page references in as we usually do, and then we will close with the comments on the last reference question about, right, when the court can decline to answer a reference question. Interestingly, first 705, you've got a bunch of interveners, so as is usually the case in the Supreme Court, all sorts of people with interests of their own, right? Usually not just 2 people fighting on the way up to the Supreme Court. By the time it gets there, usually there's underlying vested interests, and when there aren't enough, right, then all sorts of people can ask to intervene before the Supreme Court and have their own personal legal or policy preferences heard. As I said, the court's unanimous, right? We see that very clearly at the beginning. Then you have this fifth and substance doctrine, obviously not that relevant for our purposes because we focus on Section 15, but basically in that distribution of powers under 9192 pursuant to the Constitution Act 1867, that's what you look at. So of course, it's not always going to be that simple. So if the federal government has jurisdiction over patents and then passes the Patents Act, It's pretty simple. Oftentimes, it's going to pass more nuanced laws that might invoke a provincial jurisdiction, especially when there's very broad provincial jurisdictions, including the provincial jurisdiction over civil rights. And therefore, right, it doesn't mean that we'll just prevent the federal government from doing that, because then most laws couldn't be passed. And so we look at, and the court does, right, the pith and substance doctrine. So basically, if your law is mostly about a federal area of jurisdiction, then you'll be able to have an ancillary impact upon a provincial area of jurisdiction as long as it's ancillary. It's not the pith, right, the crux, the center of the law, or its substance. And of course, it's going to be especially true in areas like here, where one specific issue is split between the two jurisdictions, where marriage itself is federal, but the solemnization of marriage is provincial. Interestingly, right, the court, in rejecting all these arguments regarding the old 1867 definition of marriage, right, is going to say that marriage is no longer a religious institution. That's important, right? So marriage here is about the law. And that's true when we make these important debates, right? So marriage is about who you can marry, and then it's about how the government prevents you from getting divorced, and it's about how the government splits your money once you get divorced. That's it. There's no church. There doesn't have to be a church, at least, right? So marriage is a legal institution with legal consequences, even though it has a religious underpinning. So what we see, we might discuss that in greater detail in our Bill 21 class, but of course has a religious underpinning because the law doesn't exist in a vacuum, right? The law is going to be affected by existing social institutions, and in that case, the law is going to take marriage, which is a religious and social institution, and have legal consequences added to it. Arguably consequences that enforce existing expectations of people by formalizing them into positive law. And as a result of that, marriage generally has been understood to be between people of the opposite sex because various religious texts are going to say that. However, here the legal definition of marriage is not in itself religious. It's just legal consequences. That's what the court says when it's a civil definition. So you can go to the courthouse and get married, and conversely, your right to get married here doesn't allow you to get married within the Catholic Church if the Catholic Church doesn't want you. In fact, by virtue of freedom of religion, as we see in the decision, the Catholic Church can be discriminatory if it wants, and explicitly, right? Catholic Church can say, right, we saw Mr. Vrian couldn't be fired because of his sexual orientation. It's not exactly what Vrian says, but basically, right, it's one implication of it once you go through the provincial mechanism. But here the Catholic Church can be explicitly discriminatory, can say, we don't like gay people, we don't want them here. We don't want to give them jobs, we don't want them in our services, we don't want to get them married. And that's allowed pursuant to freedom of religion, which has an individual aspect. So freedom of religion allows you to not be forced to do things you disagree with by virtue of your religion, even though these are things that people might have a right to, like getting married. And the court's going to say that relationship between marriage and religion, about that, the court says, this is no longer the case. Canada is a pluralistic society. Marriage from the perspective of the state is a civil institution. It's 710. Living Tree Doctrines also at 710. Mention of progressive, which I mentioned, is 711. And the court says, very interestingly, the Constitution has to evolve. So as I said in an earlier session, right, not just to cover future challenges, not just to make ourselves better like 15 does. Not just to say, right, maybe in 82 we didn't care about sexual orientation, but by the time Mr. Vrian goes to court, now we do. And now that's the meaning of 15, even though it might not have been the meaning in 82. Similarly, we might, right, care about transgender rights now in a way that we didn't before. But 15 has the power to apply today, to our conception of equality today, not in 1982, and that's by virtue of this substantive equality paradigm. And the court says very interestingly, right, it's not just about things we couldn't foresee. Here it's about, right, having a stable constitutional regime. the Constitution isn't going to be a fundamental document, right, that is the only document to have greater value than usual laws, and is the only document that lasts for hundreds of years, right? You might look at the laws we passed 100 years ago, they didn't turn out so good, right? And the court says it's therefore necessary for the Constitution to be flexible, for it to be interpreted, right, as we go, and specifically here with the example of Section 15. And that's important if Canada is, as the quote said, to succeed in its ambitious enterprise, that of structuring the exercise of power by the organs of the state in times vastly different from those in which it was crafted, the Constitution, that is. And that's again at 711. Then this discussion of the distinction that doesn't exist pursuant to the reference, right, pursuant to the proposed law, right? So basically, the court's finding that, right, adding same-sex couples to the definition of marriage is not discrimination against heterosexual couples, right? That's around pages 718 and following, right? Also, there's no denial of benefits. It's one of the things where we see, right, an indicia of discrimination pursuant to the law case, right? So this is a good review of these principles, right? So pursuant to the law case, if you say you get benefits unless you're a Jew, you're taking something away, right? A benefit. And here, you're expending benefits, which is the exact opposite, so it's not a violation of the Charter. Then there's this interesting discussion of collision of rights, right? So of course then, there's sometimes going to be, right, rights that need to be balanced. It's always true, right? Because as we said, that's the very nature of the Constitution. We have Section 1 that says you can have reasonable limits on constitutional rights. And that's helpful because the government can't pass laws without infringing some constitutional rights some of the time. Especially when you have very broad rights like equality, life, liberty, and all that, right? Lots of things by the government, arguably everything by the government's going to limit your liberty in some way, right? And so Section 1 says, right, all these constitutional rights, really 1 and 7 through 15, right, are subject to reasonable limits pursuant to Section 1, and that's what we call the Oakes test. And the court says that's where the balancing happens. So if someone says, well, sometimes you'll have a clash between freedom of religion and the equality rights that would allow same-sex couples to get married, and specifically beyond the case of solemnization. So anything else, right? Since marriage is an intrinsically religious institution, right, at some point it's going to clash with various religious interests. And the court says it's not here. It's when it happens. Because when it happens, then the court's going to have to establish first an infringement of constitutional rights, and then it's going to have to balance things, as it always does. So, at some point, it's going to be impossible to respect two constitutional rights, because if you respect one, the other one's going to be infringed, and if you do the opposite's going to happen. That's what Section 1's there for. So the court's going to say, first, we can't make general statements. It's going to depend on the facts of each case, whether indeed there's a balancing that needs to happen. Namely, because there might not even be an infringement of constitutional rights. And second, right, that is going to happen under Section 1, not under our analysis. In other words, that balancing doesn't make the act unconstitutional. The fact that it might violate some religious freedom rights some of the time is not going to mean and violate on its face or in its application. Some of the time is not going to mean that the law is invalid. It's just going to mean that sometimes the law or its application are invalid, and in that case, the court's going to rule in that specific case. It doesn't generalize it to the entirety of the law itself, which most of the time is not subject to that conclusion. Then there's an interesting discussion regarding the last reference question, right? So here, as I said, various provinces had found the distinction to be discriminatory pursuant to Section 15, and then the government says we want to pass a law. So pursuant to its power to pass laws on marriage, the government can pass this law, as we said. And that's going to federalize the thing, the definition, right? So by virtue of that, the definition is going to be the same across Canada. Somehow, for some reason, the government still asked, right, I still want to know about these wicked provinces who didn't change their definition, where there wasn't a successful court challenge. Even though the government said we want to pass our marriage, right, harmonization law, regardless of what the Supreme Court says. Of course, the Supreme Court says it's not constitutional. The government would have fixed the law, but that's its stated intention. So here the court is answering an issue that is moot, because regardless of what it answers, right, the law is going to be passed if that's possible, and therefore the court's going to decline to answer the question as it's allowed to do. So we see the court here refraining from a political issue, right, so answering a question for no reason, and also these kind of underlying standing issues there. So court rules on specific cases, and similarly here, the court only does what it's asked and only does what it needs to do. And that's generally the rule, right? Courts can't rule on issues that haven't been presented, or even on issues that have been presented but are no longer applicable or necessary for the case to be disposed of. And we'll close on that, right? That's where the court mentions it around 725, right? Also says, if it said no, of course, all these provincial rulings would have been overturned. And significantly, page 726 is where the court says, the court says that this factual vacuum issue, right? Sorry, I think I got the reference wrong there. So this issue of, a right of appeal being available, not being used. So the fact that the Supreme Court's not going to rule, especially in a reference on whether the lower courts who said that the exclusion of same-sex couples violated Section 15, whether that is correct, the Supreme Court's not going to rule on, because the litigants in that case, namely the government, did not contest that lower court ruling upwards. So first the Court of Appeal, then at the Supreme Court, and we'll close on that. There's going to be another capsule for this week, which you should watch out for, regarding the United States case on the same issue, same-sex marriage, where we'll try to rate try to see the underlying equality paradigm, right? So similar context as was the case in the Gratz v. Bollinger case, which we saw on affirmative action and admissions policies for universities. And we'll also see, right, these differences, both social and political, in the way the highest court is going to approach these issues.